Welcome to today's Explainer. We are tackling something that honestly looks incredibly dense and intimidating at first glance. We're unpacking the Anti-Terrorism Act of 1997, commonly known as the ATA. Now, when you flip through a law book and see sections with letters like 11EEE or 11EE, it is so easy to get completely lost in the legal labyrinth. But don't worry, we're going to demystify this statute together. We're going to break down its anatomy and extract all that crucial legal nuance without getting bogged down in the heavy jargon.
To do this efficiently, we're taking a sort of map and tour approach. We've organized this sprawling piece of legislation into 5 logical, easy-to-digest chapters: defining terror, armed forces to the rescue, punishments and banned organizations, inside anti-terrorism courts, and finally, special rules of trial. Let's jump right in.
Starting with Chapter 1, Defining Terror under the ATA. Because before we can talk about how the law punishes terrorists, we really have to establish the foundational boundaries of the law itself.
And that brings up a really fundamental question. What exactly counts as terrorism? Like, is a standard tragic murder considered a terrorist act? Well, the answer is no. Not every heinous crime automatically qualifies as a terrorist act under this specific special law. Under Section 6 of the Act, the line is firmly drawn by intent. Terrorism here is defined by the deliberate intent to terrorize the government or the public at large. So it's not just about a single individual getting hurt. We're talking about overarching acts like sectarian violence, which spreads religious hatred, as well as hijacking, hostage-taking, kidnapping for ransom, or causing grievous, massive damage to public infrastructure. The absolute key differentiator here is the objective. The goal is to strike fear into the very heart of society or the state. And comparing the two systems really perfectly illustrates the difference. Under standard criminal law, the focus is typically on individual harm and personal motives. Let's say a personal dispute that unfortunately leads to violence. But the Anti-Terrorism Act? That gets triggered when the act is intended to terrorize society, specific groups, or the state itself. That broader, much more dangerous threat is exactly why a standard legal approach just wasn't going to cut it, and a special law was deemed absolutely necessary.
Which brings us to Chapter 2, Armed Forces to the Rescue. If a threat is this massive, who is actually authorized by the government to step in and enforce this act on the ground?
Sections 4 and 5 of the AMTA make a very specific legal distinction about who can be called in. The federal or provincial government can call upon the armed forces, and by that they mean the traditional Army, Navy, or Air Force, but they can also call upon the civil armed forces. That includes groups you might be familiar with, like the Frontier Corps, the Rangers, or the Constabulary. Both of these branches are legally empowered under this act to intervene when standard, everyday police forces are simply overwhelmed.
But to be clear, it is definitely not a free-for-all. Let's look at the Section 5 intervention rules. The law outlines very exact, escalating steps that these forces absolutely must follow. First off, they have to issue a reasonable warning to the suspects. Second, and this is critical, opening fire is strictly considered a last resort. And it can't just be a split-second decision made by anyone on the ground. It actually has to be ordered by an officer of at least the 17th grade, so someone like a major or equivalent. Finally, to ensure they can act swiftly, these forces are given the power to enter premises, conduct searches, and make arrests without needing to wait for a warrant. Moving on to Chapter 3, Punishments and Banned Organizations. Let's shift our focus to the really heavy consequences, looking at how the law scales individual punishments and totally cracks down on organized groups. Section 7 of the Act brilliantly maps out the severity of the sentences. For incredibly severe acts like hijacking or kidnapping for ransom, the penalty is death or life in prison plus a hefty fine. Now, what if someone uses explosives, but it actually doesn't result in death, say just completely destroys property? Well, the minimum sentence is still a massive 14 years, and that can go all the way up to life. And for sectarian hate speech, which is designed to fuel societal division, the punishment can be up to 5 years. So you can see how the law actively scales the weight of the hammer based on the specific nature of the crime.
But what happens when we're dealing with entire groups? Under Section 11, the state has the power to declare a group a proscribed or banned organization. And the moment they do, Section 11E triggers a systematic 4-step paralysis. First, all their financial assets and bank accounts are instantly frozen. Second, their physical offices are totally sealed. Third, any literature or publications are confiscated. And fourth, the state revokes the passports and arms licenses of its members. It is literally a total operational shutdown.
And we really need to talk about how the ATA heavily targets the wallet. Under Sections 11H to 11K, it becomes strictly illegal to raise funds, possess them, arrange financial support, or launder money for these banned groups. The crucial takeaway here is this. You absolutely do not have to be the one physically holding a weapon to face severe, life-altering consequences. Just the financial facilitation of terror alone can easily land someone a 5 to 10-year prison sentence.
All right, Chapter 4, Inside Anti-Terrorism Courts. Let's transition away from the crimes themselves and step into the courtroom. Section 4 pulls us into the highly unique, heavily guarded world of anti-terrorism courts, or ATCs.
Because these cases are so incredibly complex and the stakes are so high, the judges have to be highly specialized. While normal court judges usually enjoy standard lengthy tenures, ATG judges serve very strict 2.5-year terms. And to even get a seat on this bench, a judge needs serious, undeniable credentials. We're talking either 10 years of standing legal practice or prior experience as a session or high court judge.
There's actually a truly fascinating detail that stands out in the source material regarding this. Section 16 mandates a very specific oath for Muslim ATC judges. Before they can even begin hearing a trial, they must swear, "I shall decide the case honestly, faithfully, and I consider myself accountable to Almighty Allah." It literally grounds the incredibly heavy burden of this special justice in absolute spiritual accountability. It's just a profound reminder of the immense weight of the decisions being made in that room.
But as you can imagine, bearing that weight is highly dangerous. And that's exactly why Section 21 provides these incredible security measures. These trials are often held directly within the jail premises themselves, just to completely avoid the massive risk of transporting high-profile suspects. Proceedings can be held in camera, which means the general public is completely excluded from the room. Witness identities can be entirely hidden behind screens, and they heavily utilize video links to keep judges, prosecutors, and witnesses completely safe from outside intimidation.
And finally, Chapter 5, Special Rules of Trial. We're going to examine how the actual rules of a standard criminal trial are bent here to prioritize extreme speed and airtight security. Now, standard criminal trials can literally drag on for years, but the ATA operates on what we can call the speedy trial clock. Check this out. The police have just 24 hours to present the accused to the court. After that, a Joint Investigation Team, or JIT, is given a maximum of only 33 days to completely finish their investigation and submit a report. In the actual trial itself, the law mandates a maximum allowed duration of just 7 days, running on a rapid day-to-day basis. That perfectly illustrates the highly accelerated pressure cooker environment of an ATC compared to normal courts.
And here is a massive departure from standard law. In a normal criminal case, a confession made to a police officer generally isn't admissible in court. It usually has to be made formally before a judge. But under Section 21H of the ATA, a confession made directly to a police officer, provided that officer is at least the rank of a Deputy Superintendent of Police, or DSP, is actually conditionally admissible in court. It's a huge legal shift, explicitly designed to streamline convictions.
So what happens if the accused just decides to run away and hide? Well, the ATA has a solution for that too, allowing for a trial in absentia. If an accused deliberately tries to avoid the court process, they are issued a formal warning. If they still refuse to show up, the state just steps in and appoints a lawyer with at least 7 years of experience to defend them anyway, and the trial simply proceeds right to a verdict without the accused even being in the room. The message is clear. You absolutely cannot stall justice simply by hiding.
That exact same strictness applies to bail, too. Standard criminal bail is often granted because the system wants to preserve a person's liberty while they wait for their trial. But under the ATA, major offenses are strictly non-bailable, period. Furthermore, while standard police remand is generally pretty short, the ATA allows police to hold suspects for intense investigation for up to 90 days in extreme cases. The standard leniency of the street is entirely removed from the equation.
All right, let's pull all of this together. The core takeaway from today's explainer is really this. The AMTA of 1997 explicitly bypasses standard legal leniencies to construct an airtight, highly accelerated pipeline straight from arrest to conviction. When you look at the involvement of the armed forces, the immediate freezing of assets, the hidden witnesses, and those intense 7-day trials, it's obvious this is a highly specialized, purpose-built law designed for maximum speed, maximum security, and very severe consequences. But I want to leave you with a slightly provocative thought to ponder as we wrap up. We've seen the raw, intense mechanics of this special law today. But in our pursuit of ultimate security against genuinely terrifying threats, how do we perfectly balance the sheer aggressive speed of these anti-terror laws with the careful, necessary preservation of fundamental human rights? It is the heavy, endlessly complex weight of administering special justice. Think on that. Keep exploring the topic, and I will see you in the next explainer.